And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. My name is Amy Blake, and I'm pleased to be sitting today with Justice Kenneth Desmond and Justice Catherine Hand. We are the panel for the 6 cases that are being heard this morning in this session. The first case we're hearing is 2020-P0032, which is Commonwealth versus Craig LAWLOR. I will remind counsel that each side is permitted 15 minutes. There is no rebuttal. We have read all of your papers, and so you should get right into the issues. And when you start to speak, the timer will begin. So with that, Ms. Sacoccio, when you are ready.
Good morning, judges. Attorney Maria Elena Sacoccio for Craig LAWLOR. There's one discrete issue on appeal here, and it's whether Craig LAWLOR was deprived of his right to a jury trial as guaranteed by the 6th and 14th Amendment and Article 12, as further guaranteed by Mass General Laws 278. It was an OUI homicide, manslaughter, as tried, always prepped for a jury trial, and it seems apparent from the docket sheet that quite suddenly it was jury waived. What you do have before you is the written waiver, which, you know, mostly I'm
an affidavit from counsel at the time that addresses the reason or the thinking behind waiving a jury.
I do not. I did speak with him. He was a prosecutor brand new to the defense bar. And within a couple of months of my representation, he was back in the prosecutor's office. His position is he did everything perfectly, and I never got more than that. But aside from that, I think that's a red herring in this case, because it's not what he understood. It's what my client understood. It's what the judge's colloquy made
But it certainly
clear.
would have been helpful to know, beyond just the papers that we have, what counsel discussed with his client.
Well, there is federal case law that said you can't recreate after the fact. It has to be here on the record in jury waiver cases. And I think this record is clear. I was surprised as an appellate attorney at the form waiver, because essentially it's, if you see it, it's a record appendix number 5. I don't usually do trials. I haven't done them in years, but this is just initials, and the top is just waiver of right to be tried by a jury. And then the affirmations of what was conveyed are really, you know, asserted by, and here initials by, defense counsel. But aside from that, I mean, that was done in the middle of the colloquy, because I could see toward the end of the colloquy, the judge instructing that this be signed. She did not instruct that it was a constitutional right that he was waiving. She did not instruct that there would be a unanimity requirement. She did not instruct that she would be decider of fact, law, and the sentencer.
Well, can I ask you about the actual form that he signed? Are you suggesting that this was a form that sort of came out of whole cloth? Is this not the form that's regularly used?
I think it is the form that's used, but
Okay.
I'm not a trial attorney, but I was just kind of surprised to see it, because I would have put the attestations with all the warnings for the client to sign.
So,
And it's sort of reversed here. I don't know if all the courts use this. I really don't know.
the court didn't suggest a jury waive trial, did they?
It's not apparent from the record. It just sort of suddenly appears. This is a new attorney.
I understand that it suddenly appears, but the court didn't suggest that they go jury waived.
I don't
see that in the
have that in the record. I have no idea, but I don't think so.
The court seems to rely on Commonwealth v. Riddling for the finding that, you know, there's no set colloquy that she must engage in. And at the end of the day, she has to be convinced that it was knowing and voluntarily. How do you respond to Com v. Riddling?
Well, I think the case law is all over the place. We could just concentrate on Paveo and other cases. Essentially, what's unique about this issue is the case law in Massachusetts says it's fact-bound. So that's why I had to proceed via a motion for new trial, because we didn't have any facts about my client. The trial was conducted in such a way that he didn't testify. The poor guy had no experience with the criminal justice system. So first
when you say it was conducted in such a way that he didn't testify, what does that mean?
I mean, no one put him on the stand.
He chose not to testify.
I'm not even saying that.
So I'm asking you, what are you saying?
I'm saying that the court had no way of evaluating my client's understanding, and this court, without the motion for new trial, the facts that are relied upon to analyze whether a jury waiver is valid are the facts about the client.
Well, counsel, I apologize for interrupting, but didn't the judge inquire as to level of education and understanding of the mechanics of the trial as the judge laid them out in the colloquy?
Not really. I wouldn't say that.
I
wouldn't say that.
Well, do you agree with me? Could I just ask one question about at least one aspect of the issues that you raised with respect to the judge's failure to mention that it was a constitutional right that was being waived? My reading of the transcript is that she did tell him that. Do you disagree with that?
I do disagree. I have it right here. I understand that your attorney, that you wish to proceed by what we call a jury trial, sometimes called a bench trial. Sometimes it's just called a judge trial, which I hear the evidence. Do you understand? And he goes, yes, Your Honor. By making the selection, you understand you're giving up a trial by jury.
And then on page 7, at least with respect to the constitutional right issue, 6 into 7, the court asked, has your attorney pressured you or forced you in any way to give up that constitutional right? Do you see where I'm referring to there?
That's actually not the colloquy, though. That's, I mean, I don't know where you're reading from. In the transcript?
Yes, I am. I'm looking at the transcript from January 12th of 18, page 6 into 7.
Okay. Well, I just have, all I have here is excerpted, which would page 5 to 7 of transcript volume 1. That's the formal colloquy.
Well, no, it's the entire transcript, right?
Pardon me?
Are you suggesting that what Justice Hand just read to you, you don't have?
I'm not suggesting that. I'm suggesting that from 5 to 7 in the transcript is the formal colloquy, and that's what I've excerpted and put in my brief.
And I think that's where I was reading from, as well as the portion on page 5 in which the court says, I will hear the evidence and determine your guilt or innocence, although silent on sentencing. At least that much of it, the judge informed the defendant, and the defendant indicated that he understood. Is that not correct?
It's not what I have in front of me, Your Honor. I don't know what to say. That's not the excerpt I have for the formal colloquy. I mean, I'd have to go back to.
But we're looking at the transcript that you provided as the record.
I'm looking at.
When you say an excerpt from what?
Transcript, volume 1 at 5 to 7. That's what I have for my citation in my brief.
Well, that might be your citation, but Justice Hand and I, and I'm sure Justice Desmond are looking at the transcript, and it says what Justice Hand says.
Which is?
Well, counsel, this is your appeal. If you're making a representation that the judge didn't address constitutional right, and Justice Hand just read to you that in
page
fact
14 of your brief, on
yes.
Page 14, you draw the language from the colloquy itself.
I have a revised brief. I'm not sure.
Page 14 of it.
Yeah. I'm sorry, I don't have it. Maybe our pagination is not consistent. I mean, from the excerpt, what I have of the colloquy, I don't think it's adequate. And I don't think it's adequate on many grounds. And it makes it appear that it's just a mundane decision that the defendant is making.
Let me apologize to you because I was looking at the appellee's brief. So in fairness,
okay.
It's page 14 of the appellee brief.
Could I ask another question, counsel?
Yes.
Do you have a case that says that the judge is required, with respect to the first point that you raised, that the judge in the colloquy is required specifically to explain that a jury would have to make a unanimous verdict?
There's no, the cases, as I said before, are kind of all over the place. Some cases rule that way. Specific unanimity is paramount. In fact,
What's your best case for that?
I think it's Paveo, but also there's the subsequent U.S. Supreme Court case, Ramos, 2019. There began no question either that the Sixth Amendment's unanimity requirement applies to the state and federal criminal trials equally. This court has long explained that the Sixth Amendment right to a jury trial is fundamental, and it goes on and on and on. So that's a reinforcement of the unanimity requirement.
Does it say that the colloquy, does Ramos, and I apologize for having to ask this, but does Ramos say that the colloquy on a jury waiver must include that particular language?
Well, interestingly, in federal court, they don't have a prescribed colloquy. In fact, they rely more on the written waiver as kind of the solidification of the understanding. It's a murky area, I agree. But I think within the context of this client who had absolutely no experience in the criminal justice system, he was along for the ride, I mean, essentially, and he had no understanding of what he was waiving. I don't think the judge's colloquy, it was all very rushed that morning. It was a case in which I've never read a transcript where a judge took more control over the case. So, you know, a lot of stuff would have been objectionable had we had a jury, but we didn't.
But those issues are not raised in your appeal, correct?
Pardon me?
But those are not issues that are raised in your appeal. You're focusing on the colloquy.
Right, you really can't raise them because, I mean, a lot of the issues as an appellate attorney that you find are because of their effect on the jury, whether it's opening argument that's improper, closing argument that's improper, inadmissible evidence, prejudicial statements, all that sort of stuff becomes, you know, a footnote in a case where the judge is really the jury.
So I just bring it back to the issue of the transcript and your brief. I'm looking at your brief at page 16, and I understand what you're saying when you're saying that portion,
that
because
is
it
the
looks
colloquy,
like you made,
right.
Well, but unfortunately it's not. It's only a piece of it. You stopped before the judge asked about giving up that constitutional right. I just compared what you excised from the transcript to the transcript. What you have is accurate. The problem is that you stopped.
Okay. I didn't realize that, and I apologize to the court. But I still, my import is my position is still the same. I don't think that this was an adequate colloquy. I don't think.
Can I ask you this though, based on what you just said in response to the question, if there were errors during the trial, whether it's a bench trial or a jury trial, I want to understand, are you saying you can't raise questions of the admissibility of evidence or questions about improper argument when there's a bench trial?
It's very difficult because most of the time, this court will say that the judge is able to set aside, you know, and excise from their consideration prejudicial evidence. It's just a very hard road for an appellate attorney. This is the third one, and every time I get a jury waive trial, I know it's a challenge. And I think that's why it's so important that there be some clarification on this particular issue. I think we have the new US Supreme Court case. We have, there's another federal case, Laney, that says that this is structural error. It's not even, you know, I think I asserted because it was an appeal from a denial of a motion for new trial. The standard review is usually substantial risk of miscarriage of justice, but federal court seems to think this is structural error. And I can see why, because there's no way to weigh and evaluate an effect on a jury, really. You know, would the verdict have been different? I mean, there's just no way because we don't have a jury here.
But the question in this case in terms of guilt or innocence was, who was driving, right?
It was, and to speak to the immediate facts, 3 lifelong friends out, obviously all of them very, very drunk because there was video in every bar that they stopped. The owner of the car was Craig LAWLOR. At some point, the car stopped, and then I think there's a 20-minute interim. No one knows who got in the car, who got out the car, who was driving at that point. I don't know. I think it's at the last minute. The passenger in the car asserted he was the passenger. He said he wasn't the driver and testified that my client was the driver. But that was last minute. Up to that point, no one really had a memory. And I believe no one had a memory because if you saw the video, you'd see how drunk they were. But I mean, it's a tragedy, without a doubt. These are lifelong friends.
I think unless the panel has any other questions, we're going to have to leave it there. Okay, seeing none, thank you very much, counsel.
Thank you.
Good morning, Your Honors. May it please the court, Monica De La Torre on behalf of the Commonwealth. I would also like to acknowledge the deceased victim's family and the surviving victim and his family who are watching via the YouTube channel, as well as the trial prosecutor, Caitlin Grasso. The Commonwealth is respectfully requesting this court to affirm the defendant's convictions and affirm the denial of the motion for a new trial. This case is squarely decided by Commonwealth versus Hendricks, which is cited in our brief. It's 452 Mass 97 2008 case, which holds that the omission from a jury quality of the jury unanimity instruction does not invalidate a jury waiver. There is no requirement that the defendant be specifically informed that the verdict must be unanimous, and that decision has been affirmed by an unpublished decision as well in this court, which is cited in our brief as well, which is Johnson. I do think that the situation in this case is different than that of Commonwealth versus Paveo. In that situation, there was no colloquy at all, and the court was determining whether that was going to be a structural error due to the requirement of there being a jury colloquy. I do think this situation is also different from Ramos versus Louisiana, which is the Supreme Court that my sister cited, which does, of course, emphasize the importance of the unanimity of a jury trial. The situation in that case determined whether Oregon and Louisiana's jury, they only required a 10-2 jury, and whether that was sufficient under the Sixth Amendment. In terms of the jury transcript itself, I just want to note that on the transcript that we have, it is defense counsel who volunteers the first initiation of a jury waiver on the first page, asking if he should discuss the jury waiver with the defendant downstairs. That's on page 3. They do have a 20-minute break in the transcript that they have time to consult and then comes back. My version of the transcript, I do have, I believe, a similar one the court has, that the judge, I do have the judge instructing, that they will determine guilt or innocence. I believe she does that twice on pages 5 to 6. She does also ask the defendant if defense counsel had pressured in any way to give up a constitutional right on pages 6 to 7. And the defendant gave—
What do you say about the waiver form? Is that the standard form that's used?
That is the standard form that is used. And on that jury form itself, the defense counsel affirmed that he instructed the defendant on the jury unanimity requirement.
And what, if anything, should we make of the fact that we don't have an affidavit from trial counsel?
Sure. As the motion judge here, I do, it's conspicuously absent here in terms of the details about the whether jury counsel, instructed the defendant as to unanimity. And there's also no details in terms of the record that we have before us about any efforts to reach out to defense counsel. So I do think that is a prejudice against the defendant here in evaluating the record. In particular here, when looking at the motion for a new trial as well, the motion judge here was the trial judge. She was the one who was able to evaluate the answers of the defendant and look at the defendant's demeanor. And that is also entitled special deference to in this court, excuse me. If there are no further questions, I'm happy to answer further questions, but if there are no further questions, I will rest.
Let me check with the panel. Seeing none, we will take the rest of 11s. How do you pronounce your client's name?
It is ALJOE, as far as I know.
Okay.
And we are back live and on the record.
Thank you very much. Our next case today is 2019 P1196 Commonwealth versus Sheldon ALJOE. Let me introduce the panel. My name is Amy Blake, and I'm pleased to be sitting today with Justice Kenneth Desmond and Justice Catherine Hand. Although we are doing this on the Zoom platform, the rules remain the same, which is that each attorney will have 15 minutes to present. There is no rebuttal. When you begin to speak, you will see the clock in the upper left-hand corner where the current court seal is located. And unless there are any questions, we can get started with you, Mr. Levins.
Thank you very much, Justice Blake. As you well know, this is a case that involves two counts of indecent assault on a person under 14, and one was allegedly occurred in the spring of 2016, the other one in November. As an administrative matter, I'd just like to say at the outset that any argument which appears in my brief that I don't touch upon orally, I am not waiving.
Understood.
Okay, now, I think that this case needs to be reversed because there were a number of errors here, and I want to start with the SANE report that came into evidence. This report came in as a medical report, supposedly, because it says that right on the report, supposedly under 233-79G. I'm sorry. The problem with that is that there is no proper certification under 239-79G, although it says on, I believe, the first or second page that it is signed under the pains and penalties of perjury. The fact is that while a signature line appears, there is no signature there. So I don't think that it comports with 233-79G, apart from the fact that I didn't see anything in the record that tells me that a green slip was provided for the court, and that 10 days notification was given. So I don't think that it comports. Now, the importance, obviously, of it comporting is that the Commonwealth is allowed to get into evidence any of the hearsay statements in that report, but there are other problems with that as well. First of all,
Attorney Levins, some of the same report was redacted. Were you involved in what portions were redacted?
No. Some other
Was
issues.
trial counsel involved?
Don't know. I assume he was, but I don't know. And maybe I should have inquired, but I didn't.
And there's a suggestion in your brother's brief on page 21 that trial counsel conceded that the substance of the SANE report was actually helpful to his case. So assuming for the sake of this question that it was error, and I'm not suggesting one way or another, but assuming that it is, what's the prejudice if it ultimately was helpful to your client?
I don't know why he would have conceded that. I don't think that I would have, and I can't get into his head, certainly at this late date, so I don't know. And I don't know what the basis for that is, that a Commonwealth's counsel would have made that statement. So
there's a citation to the record where trial counsel says that.
Says that it's helpful?
Yes.
All right, I just don't know that.
So if indeed it was helpful to him and part of his strategy not to ask that it be excluded. What do we do with that?
I don't know how, I don't know how to answer that because he objected to it. He objected to it going in, as far as I remember.
But then if he changed horses midstream and decided that it was helpful, what's the impact of that change in viewpoint?
I'm sorry, say that again.
If that's, you're correct, I think about that, but if, to Judge Desmond's point, if then at a later time, counsel indicates that that's actually helpful in its redacted form, that being the record, how does that impact our assessment?
Well, I don't know because I don't know why he said it. I don't know what he had in mind. So,
well, let me read this to you. This is at page 6 of volume 2, starting at line 24. I'd suggest, Judge, that the specific finding is inconclusive. It says everything's normal. I mean, that actually helps me. So the judge then says, so my question is, and defense counsel interrupts and says, as long as we redact the other stuff, the rest of the report helps me because the finding was inconclusive.
well, it may have been helpful that the finding was inconclusive, but I don't think it was helpful that the same report goes into evidence because there are other things in this, you know, not the least of which is that this whole incident happened at all. And it turns out that since you can't get this into evidence under 279.33G, I mean 233.79G, because it doesn't comport with the statute. Apart from that, it's not even a first complaint. It's really a third complaint. The first complaint was to the guidance counselor at school. The second complaint was to the detective at school that same day, and this would have to be a third complaint.
Didn't the young girl, I believe it was your client's stepdaughter, didn't she text her friend almost immediately or the evening that it was alleged to have occurred?
Well, I'm glad you raised that, Judge, because for a couple of reasons, although I do want to come back to the same report. And the reason I want to raise that is because that might have actually been a fourth complaint. But in addition to that, please note that those texts were submitted in November as if they followed or reported the November event, when in fact there's nothing in there about the November event. So they have to have been reporting the first event, which is when he, because the second event has to do with his taking her hand and putting it on his penis, and the first event had to do with something totally different. So if it's the first event, this is 6 months later. Now I know we're a long ways from fresh complaint, but you know, when you get out to be 6 months, you know, query how reliable is this report?
Do we agree that the primary issue at trial was identification?
Well, I don't know if it was primary, but it was significant. And with regard to identification, she saw a tall, slim man with a ponytail, not even dreadlocks, but a ponytail. She was
This is the stepdaughter identifying her stepdad.
Identifying somebody, right?
And she identified him in court as well, right? At trial?
Yes, but he was at the defense table. She was on her stomach. The room was dark. It's pretty clear she didn't really see who it was that, you know, assaulted her. She definitely sees a person with dreads at the defense table. And so that's really I think a first-time identification.
The victim had lived with the defendant for 10 years before this set of incidents, is that right?
Something like that.
Did the evidence show that he was the only male in the apartment at the time of the offense or alleged offense?
I don't think there's any other evidence other than you know, the young boy, but it certainly could not have been him. But it doesn't exclude that it might have been other people, and her identification, I think, was unreliable. I mean, you can make the jump because there was no other male in the house for that period of time. You could make the jump that it was him, but again, she's half asleep, and that's clear from the record. She's on her stomach and the room is dark. I don't understand, other than by conjecture, I don't understand how she could have concluded that it was him.
Doesn't that go to the weight of the evidence?
Yes, but the weight of the evidence is important when you consider a lot of other things, like, for example, that this text material between her and Ashley was 6 months old. And the fact that the same report, I think, should not have come in at all. This was not a medical report. She wasn't a doctor. She wasn't even at the exam. If you read the record, the transcript, you'll see she wasn't even at the exam.
Counsel, I just had a chance to look at the transcript, and trial counsel actively participated in what was redacted or not from the SANE report.
I'm not disagreeing with that.
Okay. When I asked you earlier, you said you weren't sure. I just wanted to close that loop. So let me ask you about the text messages. What do you, in the record do you base that these messages were 6 months later than the incident?
Well, if you look at her description of the incident in the springtime, it was that he put his hand under her skirt, it touched the front part of her thigh, moved his hand up, touched her vagina, and then put his hand or his finger in her, quote, hole, close quote. There's nothing in there about that as far as I remember. It's all about him coming into the room and putting his hand or her hand on his penis, which is what the November event is all about, as she testified. So that raises the issue of whether we're talking about one incident or two incidents, to say nothing for the whole issue of the reliability of these texts. Secondly,
do you have a case that says that the first complaint has to be within a specific period of time?
No, I don't, because that falls under the fresh complaint doctrine, which I don't think has disappeared completely. I think the question of how recent it was goes to relevance and prejudice. This is 6 months later. It's a long time to wait to make a complaint.
It's also a child. It's also a person under the age of 14.
I agree. And there may be some different standard in that regard.
Why do you think the judge was required to sua sponte declare a mistrial?
Oh, okay. Well, I think I laid out about 2 pages of the transcript whereby I think the judge was thoroughly frustrated with the district attorney trying to rein her in keeping her from getting this witness to use the word rape. That's where it all started. And there was an objection because, the judge pointed out that this is not a rape case. She nevertheless persisted. And finally, the witness uses the word rape. Now, well, I think we all agree that that's a highly prejudicial word.
But the question that the prosecutor asked was, is there a procedure to determine whether or not biological samples would be taken from an individual? The witness then said, yes, it's a SANE examination. It's pretty much a rape kit.
Yeah, I'm not suggesting or arguing prosecutorial misconduct. What I'm saying is that when the witness blurts out the word rape, I think the judge at that point, given the fact that he himself recognized that it was highly prejudicial, I think that he should.
sustain the objection and strike it, right?
Yes,
And
Yes.
how many times did the word rape appear in the transcript as before the jury? Just that once?
I think it may have appeared once before that in this testimony that starts at page 94, but I can't say for certain. I'm not sure on that.
Defense counsel was a very seasoned veteran defense counsel in this matter, right?
That is accurate as far as I know. Doesn't mean that that everything goes smoothly with seasoned defense people or prosecutorial people. In any event, I think that word rape getting before the jury mandated a sua sponte mistrial, which of course didn't happen.
I think we're going to have to leave it there as your time has expired, but let me just check with the panel. Are there any additional questions?
No.
All right, I see none. Thank you, Mr. Levins.
Thank
Mr.
you,
Shorey.
Justice Blake. Thank you.
Good morning, Your Honors, and may it please the court. Benjamin Shorey on behalf of the Commonwealth. If I can just spend the bulk of my time here clarifying what I can from the record, addressing the medical records first. You know, I would just point the court to, I think there is a disparity between the two appendices, but I do include in my appendix the exhibits that were actually admitted at trial. And there's an issue during the transcript about whether they were properly certified. The prosecutor says, yes, they are. The judge says, can I look at a copy of that? Prosecutor provides them. And then the exhibit that's admitted at trial clearly is properly certified.
And that's Commonwealth Appendix 9, which was trial exhibit 4?
Correct, Your Honor. And that's correct.
Okay.
I will note is in terms of redactions on that exhibit, there are a couple of things that were not redacted. But I would just point to the fact that the trial prosecutor says the reason to admit these exhibits really is, or this exhibit is to show the investigation that was done and that the Commonwealth took steps to investigate. And the judge and the prosecutor both were open to really any redactions that the defendant wanted to make. And so the defendant, participated in that. There was no issue as to further redactions. And I think ultimately that the what came in was admissible for the most part. There's a statement or a summary of what the victim alleged, which I think is admissible under Dargon, even though the parties intended for it to be redacted in this case. And so then what we're left with is just one line on page 18 of the Commonwealth Record Appendix I believe it's at the top, just noting that this is a sexual assault exam. But I think that's all we're really left with if there's an issue of prejudice here at all. And then as for
Attorney Shorey, I'm sorry to interrupt you. Could I ask, my concern is that it didn't seem to me like there was much of a suggestion up to the point that exhibit was entered that there had been an incomplete investigation or a lack of investigation by the Commonwealth. And this therefore felt I saw the argument that the defense made that it was more of a first complaint issue. Can you speak to that a little?
I mean, I do think at the end of the day, there wasn't certainly in terms of the closing argument or otherwise, the Commonwealth, the defendant didn't make a Bowden defense. But, I don't think the Commonwealth is required. The Commonwealth can affirmatively present their evidence and their case. And especially in a circumstance like this, where the judge is essentially cut off from making a prejudice probative value analysis, where the defendant jumps in and says, oh, okay, if we can add the redactions, I actually like the substance of what's in this report. So, I think that the Commonwealth was well within or the judge was well within his bounds in letting the Commonwealth affirmatively present this evidence, given that both parties in the end wanted it in. As for the text messages, just to clarify the record, the text messages were admitted as first complaint evidence as to the second incident only. And page 5 of the Commonwealth Appendix, that's the text messages describe that event. Again, maybe a disparity between the two appendices, but the exhibit that actually was admitted redacted any reference to the prior incident. So it wasn't, those messages did not refer to the spring incident. They eventually, after defense counsel suggested during cross-examination that the victim had never told anyone about the first incident, or at least that the defendant had in fact touched her instead of just trying to touch her, then the judge allowed the prosecutor to rehabilitate the witness by noting that she had, or eliciting that she had told her friend about that incident in these text messages. But the text messages themselves still were not admitted on that point.
Do you agree with your brother that fresh complaint is still alive and well in the Commonwealth?
I apologize. I'm not sure I understand the question, Your Honor.
Your brother suggested that in addition to first complaint, fresh complaint is still alive and well, and that perhaps King didn't close the door on evidence of fresh complaint.
No, I think it had to be the first complaint here, or there had to be a specific finding about an exception to that. But I think it clearly, I mean, the evidence was the victim, the crime happened, the victim ran out of the room into her bathroom and then to her own bedroom where she immediately texted this. So I really don't think there's any issue there about this being the first complaint where it did only address that incident. And then if I can just address the defendant alleges that the prosecutor was persistent in trying to elicit this issue of the rape kit, and that factors into why a mistrial was required here. To be clear, I think there's a sidebar conversation, and the prosecutor is trying to hear from the judge specifically what she's permitted to ask, and runs by the judge a specific question. The audio was low, so we missed some of what that question is, but we get the beginning of it. And then she appears to ask that exact question that was approved by the judge. And the answer by the witness is really not responsive to that. So I really don't think there's any persistence in trying to, the back and forth all happens at sidebar, not at all with the witness in the sense that the prosecutor's trying to get this out. So I don't think that's supported. If the panel doesn't have any other.
I just want to ask you about the ID. At any time in the investigation, she was not asked, is this your stepfather? Or she didn't say this was her stepfather until the courtroom?
Oh, I don't know that. I don't think that's right.
Okay.
I don't think it comes in evidence. But
I'm trying to understand the sufficiency claim of ID.
So I think the defendant's claim is that because the victim describes the person who attacked her on these incidents, and does it the first time, she says it was kind of dark in her room, but she also says she sees his ponytail, she sees his t-shirt, and she's asked, who was that? Do you see that person in the courtroom? She says, yes, he's there. In the second incident, again, she says she turned, she looked right at him as she was leaving the room. She noticed things about him. She never says she saw his face. It's not, she doesn't say anything to the contrary either, I don't think, but it's clear, like, these are not the best lighting conditions. But I don't think there's any case that ever suggests that a defendant's there has to be some, especially where this is a stepdaughter who's lived with the defendant since she was born, or since she was an infant, needs to specifically delineate the basis for that identification, that she saw his face or what part of his body specifically this identification was based on. It's clear she saw him. It's clear she'd known him for 11 years, and she's very clear in court. She's pointing to him saying that's the person. I think that identification is more than sufficient, but it's also supported by other evidence in the record. The defendant's the fact that the defendant is the only person the male in the home. The defendant at one point tries to elicit that other people sometimes come to the home, and the victim says actually only a couple times were there ever friends at the house. And before the second incident, the victim walked home from school and walked through the home. So there's really, she sees who's there. I think the evidence
she did never identify him by name, right? For someone who lived with him for 11 years, she's under 14, 5th or 6th grade, somewhere in there, but never identifies him by name.
I don't, Your Honor, I'd have to look at the record exactly what that refers to. I think that when she's asked about, she says that her text message right away identifies him. There's no doubt about who it is. I think the defendant elicits at some point in cross-examination, when you first talk to your counselor or whatever at school, you just described his appearance. You didn't say his name or something like that. I do think that's in the record, but I don't think there was ever, a meaningful dispute about whether she knew who it was from the start. If there are no further questions, I would rest on my brief.
Seeing none, thank you both counsel. The matter is under advice.
And we are back live and on the record.
Thank you. The next case this morning is 2020 P0274, Commonwealth versus DIRRELL, Warwick. Good morning, counsel. Let me just introduce the panel. My name is Amy Blake. I'm pleased to be sitting today with Justice Kenneth Desmond and Justice Catherine Hand. Although we're participating on Zoom today, the rules of the courtroom still apply. So each side is permitted 15 minutes. There is no rebuttal. We have read all of your materials, so you should feel free to jump right into your arguments. And with that, Attorney Peterson, when you're ready, the timer will begin.
Good morning, Your Honors, and Attorney Wendell. May it please the court. As Your Honors know, this is an OUI case where the defendant was found properly parked in a mechanically inoperable car on the side of the interstate.
Let me ask you one question right there, Attorney Peterson.
Yes, Your Honor.
When you say properly parked, I know the evidence is such that the car was not obstructing any other vehicles, but is there any other record evidence that says it was properly parked or describing how the car was parked?
Your Honor, I believe that the most conclusive statement comes from Trooper Sheehan in this case, where he agrees that the car was parked in a way that did not indicate it had been driven in a negligent or improper fashion. It was parked in the breakdown lane of the interstate, which is, as Your Honor knows, for the purpose of broken down vehicles. And I believe the evidence would show the evidence showed in this case it was a broken down vehicle. So
well, I'm not sure about that, but what's the record cite for it was properly parked?
Yeah.
Excuse me, Your Honor. It was volume 2, page 137. On cross-examination, Trooper Sheehan agreed that the car was not parked in a way that indicated it had been driven in a negligent or improper fashion. What's the direct quote? The issue here, Your Honors, is that the Commonwealth did not prove operation while under the influence. There is a secondary issue. It's conceded by the Commonwealth. I'm glad to take questions on it, but I was not going to feature it in my argument here. The crucial facts are that no officer saw Mr. Warwick driving the vehicle. So the Commonwealth must either show that Mr. Warwick was operating the car to the location while he was under the influence, or he operated in the presence of officers while under the influence.
So it's a fair inference that he operated it on a highway to get it to the side of the road.
I'm of course not conceding that, Your Honor, but I believe that
So let's assume that that's what I think. So
doesn't he concede that?
Drive it there. I'm sorry, Judge Desmond.
I'm sorry, doesn't he concede that?
I believe that he does. I believe that his statement is that he was coming from an establishment called Maximum Capacity.
Okay.
So then the question really is, was he under the influence at the time that he drove it? It's really not operation. It's really the under the influence. That's the issue.
Yes, it's the word while in the statute. Was he, did he operate the car while under the influence? So, and I believe the Commonwealth, I'm sorry, Your Honor.
That's all right. I'll let you finish that answer.
So I believe the Commonwealth can either rely on that he drove the car to the location while under the influence, or that he operated the vehicle while the officers were there while under the influence. And I believe the Commonwealth did not prove either in this case.
Wasn't one of the cases that is cited, I think, in both your briefs is Commonwealth v. Noor. I think it's an unpublished decision. Isn't that very similar to the facts in this case?
It is, Your Honor. That
and they found it sufficient there, right?
I believe there were some other facts there. In Noor, the defendant was found in the driver's seat. The girlfriend was in the passenger seat. The headlights were on and the keys were in the ignition. I think it's a crucial fact there.
Well, here the headlights weren't on, but the keys were in the ignition, so it seemed. But nevertheless, as far as how the car got to be there and while under the influence, doesn't that square with Noor?
Well, Your Honor, the court is really more concerned in that case with Leonard and the fact that there's another party on the scene and whether they could prove that which party was the driver. The court did, in a footnote, though, specifically reserve the issue of whether the car could have been operated while it was out of gas.
They said we need not reach the question, but I'm asking, do we need to reach the question? Aren't we on the same footing as Noor?
No, Your Honor. I believe that since the keys are not in the ignition, since when the officers arrived, the car is not in any way being operated under any definition.
But he concedes driving there.
He concedes driving it to the location, Your Honor, but we have no idea when that happened. The case here is that the officer didn't feel the engine. There was no testimony about when Mr. Warwick supposedly left Maximum Capacity, although I believe that there was some testimony that that bars close at 2 and that this happened around 3 a.m. I don't believe there's any evidence of when Mr. Warwick left or when Mr. Warwick stopped drinking. I believe the case that actually is more directly on point on this issue is Sutterth, which is the Massachusetts Appeals Court case from 1994, where the defendant there was parked legally asleep at the wheel with some beer cans in the vehicle. The court specifically there said there was no inference from those facts that the defendant became intoxicated prior to going to the scene because the car was parked normally. Cited all the cases that I point out in my brief that talk about the fact the car was parked half in the road, half not in the road, indicated that someone had been under the influence when they operated the vehicle to that location.
Here there was no evidence that there were any alcohol containers, or I understand that, you know, one of the officers did the inventory, has no memory of whether he saw it or didn't see it, and the other officer didn't mention it at all, but there's no evidence that there was alcohol containers or empty beer cans or anything of the sort, right?
I don't believe there was any positive evidence of that, Your Honor, but I don't believe there was any. I mean, as Your Honor points out, both of the troopers who testified didn't say distinctively whether there was any found or not. They said there was an inventory search performed. They did not say whether there was anything found in the car. And I believe the crucial distinguishing factor in Sutterth, though, is that the ignition, the car's ignition was on when the troopers approached it, or the officers in that case approached the car. That's the crucial difference in the Sutterth case.
I guess so. I mean, I certainly appreciate your argument, but what I keep coming back to is we're looking at this through the lens of the light most favorable to the Commonwealth. And you and I know that if they found alcohol in that car, right, we would know that. That would have been before the jury. The inventory would have been before the jury. So in the light most favorable, why can't we infer that there were no containers in the vehicle?
Because I don't think that there's evidence either way of that. I mean, I think that Trooper Sheehan testifies that he almost immediately takes the defendant to and books him. He doesn't testify that he does the inventory search, and it's not clear who did the inventory search according to the record. So I don't believe we can assume that from the absence of evidence either way that there must necessarily not have been alcohol in the car.
So what we have is a guy who's arguably passed out behind the wheel on a major highway, who reeks of alcohol, who admits that he just came from a bar at 3 a.m. in the morning, who doesn't respond to an officer who's yelling at him and knocking on the window and has to conduct a sternum rub to get his attention. And when asked for his license, offers the officer a $5 bill. So is there any dispute that he's under the influence? Let's start there.
I believe the evidence was sufficient that he was under the influence based on those facts and based on his failure of the field sobriety test. I don't believe that I can argue with a straight face that he wasn't under the influence at the time the officers came to him.
And do you admit that at some point he put the key in the ignition, or the keys were in the ignition?
Well, so I believe that evidence is that he put the keys in the ignition to get out of the vehicle. That would imply that the keys were not in the ignition before. So yes, he did put the keys in the ignition of a car that would not start. And I addressed in my brief I believe the unsettled question of whether an inoperable vehicle can be operated.
Now, do we know that it was indeed inoperable? We know that the defendant couldn't start the car, or he says he ran out of gas. And we know that the officer asked the defendant to try to start the car. I think the testimony on cross-exam was that the defendant turned the key, not the officer, and it wouldn't start. Do you agree with that?
I believe that would be sufficient to say the car was inoperable.
There was no expert testimony that said the car was inoperable, right?
There was no expert testimony to that issue, no, Your Honor. But the fact that I believe that the Commonwealth at one point said that the jury would be permitted to credit the fact that the defendant said that the car was inoperable, and the fact that whoever tried to start the car, it did not start at that time.
They're permitted to credit it, but they're not required to.
I believe that that's the only evidence in court that was presented, is that the car was inoperable. I don't believe that there would be any way to doubt that according to the evidence.
So running out of gas legally renders a car inoperable?
So I cited some out-of-state cases, and I believe the court in Noor, that case, the 2015 unpublished case, the court there almost kind of assumed that that car there was out of gas and therefore would be considered inoperable. And I believe that some of the out-of-state cases that I cited also go to that point as well, Your Honor, is that the car was out of gas, and that's the defendant's version. I believe it's undisputed that the car would not start when the key was turned. But I believe that the evidence here, the Commonwealth did not produce any evidence that Mr. Warwick operated the car, or that he was under the influence when he drove to the side of the road. Here relies on speculation, and as Your Honor, so there's no direct evidence that he drank prior to getting in the vehicle. He came from a restaurant, but he was never asked whether he drank there. There's no evidence that he consumed alcohol prior to getting in the car. So but even if we assume that he did have alcohol prior to getting in the car, I believe that we would have to speculate as to whether his blood alcohol, whether he was under the influence at the time that he was driving the car, because as Your Honor knows, and as this court has recognized numerous times, blood alcohol level continues to increase after consuming alcohol. It is very possible, according to the facts here, that Mr. Warwick was not under the influence. He drank at the bar. He was not under the influence when he operated the vehicle to the location. His blood alcohol continued to increase while he was parked on the side of the road.
I'm sorry to interrupt you, but this case was tried as an impairment case, not as a BAC case, correct?
I believe it was. There was no blood alcohol result introduced.
Do you think it's fair on these facts to look at the fact that he ran out of gas as indicia of impairment?
I don't believe that's fair. I mean, I think that's something that, you know, people run out of gas for plenty of different reasons. People run out of
What
gas.
time of the night or morning was it though?
It was 3 a.m. And I believe that, you know, the fact that somebody, you know, could be trying to get home, trying to, you know, they're looking at their car and they say, well, I know my car, it won't run out of gas. And then all of a sudden it does. They think I can fill it up in the morning. I mean, people run out of gas for plenty of reasons. I don't believe there's any case law that says that running out of gas is indicative of operating under the influence. And I don't believe that's an inference this court can make here. And just to touch briefly in my last couple of minutes on whether operation occurred at the scene, I would initially point out that this issue was conceded by the Commonwealth in closing argument by the same attorney representing them on appeal, that there was no operation while the officers were present. As I said, it's unsettled whether turning of a key in an inoperable vehicle constitutes operation. I believe that legislatures across the country have attempted to solve this question by changing the law to say that a car, you only have to be drunk in possession or under the influence and in possession of an automobile. I believe I pointed that out in relation to New Hampshire specifically, where they had a case that said that an inoperable vehicle could not be operated. And then the legislature later changed the law to kind of get around that decision. There's been no change here. Similarly, the court should settle that question today and hold that turning the key of an inoperable vehicle, as here, cannot constitute operation, because it will not set and power the motive power of the vehicle, which is the standard for operation. And just briefly, he only turned the key in response to the exit order. I believe that the Commonwealth and I both spill a lot of ink about why that happened, but I believe it's speculation about what. We just know that he only did it in response to the exit order, and I believe that's a crucial fact here that shows that the Commonwealth cannot use the police a response to an exit order to supply an element of their case. If there are no further questions, then I would rest on my brief, and I appreciate the opportunity to argue in front of you guys.
Let me check with the panel. I don't see any. Thank you very much, Attorney Peterson. Attorney Wendell, when you're ready.
Yes, good morning, and may it please the court, Assistant District Attorney John Wendell for the Commonwealth.
And you were the trial prosecutor?
I was, as it happens. I took the case as a favor to a colleague.
Attorney Wendell, had he turned the car and actually started the car, instead of just turning it and unlocking it, would you still say there's no operation?
That would obviously be operation, Your Honor. And well, frankly, what I said in my closing argument, that doesn't actually go to the sufficiency of the evidence. What I asked the jury to conclude, the way I led the jury in my closing argument, does not have any impact on the standard of review for this motion, which is whether the evidence taken in the light most favorable to the Commonwealth is sufficient as a matter of law. For all I know, the jury disagreed with me, said I was being ridiculous, and that was the method by which they reached their conclusion. If as it happens, the evidence was sufficient. And yes, the Commonwealth would say that turning the key of this vehicle is legally sufficient to be operation. And that goes, I would like to just emphasize the standard of the motion for a required finding, the standard of light most favorable to the Commonwealth. That is, all evidence in the Commonwealth's favor, all credibility determinations in the Commonwealth's favor, all reasonable inferences found for the Commonwealth. And so the question of whether the vehicle is actually out of gas is a question of whether the jury believes what the defendant said to the officer and whether they believe the officer's statement that it was in fact said. Now,
If the car was out of gas, does that render the car legally inoperable?
I would not concede that, no. However, and I did say in my brief, there's much assumption on the part of the defendant that a car that is out of gas is legally inoperable, but there's no case law and no Massachusetts statute that says so. There are, to be fair, there are other states that have made that decision, but the other states have their own distinct OUI type of statutes. So their interpretation is not necessarily relevant to the interpretation of our own OUI statute. But I do not concede that the light most favorable to the Commonwealth would be that the vehicle's out of gas, because that requires the jury to credit that statement, and the jury is not required to credit that statement. They could have said, oh, he's lying to the trooper, trying to excuse why he's parked on the side of the highway instead of having taken the exit that's right there.
So assume, and I'm not going to suggest that your brother absolutely conceded these things, but assuming that there's operation and assuming that there's under the influence, tell me what the evidence and the reasonable inferences are of the while, if you will.
All right. Well, if we're going with the turning the key at the scene, that's rather obvious. As for if he was under the influence while he was driving from maximum capacity, what the trooper said was a bar, to the side of the highway where he's found, first of all, that vehicle is not in ordinary condition. It's in the light most favorable to the Commonwealth under this particular theory. And no, I'm not talking out of both sides of my mouth. It's a question of what the jury chooses to believe. And in this case, if the jury says, oh, the car is out of gas, that's weird. Why, if he's so low on gas, didn't he get off the highway? That would be the vehicle's not in ordinary condition. Besides which, the vehicle is parked on the side of a highway, which is not an ordinary place to park a vehicle. The highway, it's a breakdown lane. It is for vehicles which are broken down. It is for vehicles which are in distress. It's not an ordinary place to park. So to suggest that the vehicle is ordinarily parked on the side of a highway is, well, it's frankly impossible for a vehicle to be ordinarily parked in that location, because that's not a place where you're allowed to ordinarily park.
Well, do we ordinarily see cars that are broken down in broke down lanes?
Yes, we do.
So to that extent, I mean, isn't your brother's argument fair and reasonable?
Yes, but again, that goes to the fact that the fact that the vehicle is broken down because it's out of gas, that is in and of itself strange.
I understand.
If the vehicle couldn't start because, oh, hey, he had somehow blown all 4 tires, and he had managed to wrestle it over to the side of the road, and it's slightly cocked, but that's the best you can do with all 4 tires being blown, that's not indicative of anything strange on the part of the operator. But
was there evidence about what the sternum rub, when that's used, why it's used, what conditions it's used under?
It was a very brief discussion. If I recall the record correctly, and my memory of the trial, the basic purpose of the sternum rub is that it causes discomfort to a rather sensitive part of the body, which is therefore usually enough to wake anyone, even from alcohol-induced unconsciousness.
Well, I guess that's the question, right? Was there anything about this is used when someone's under the influence of something versus if they're having a medical condition? What significance or what can we infer from that?
I don't recall specifically, but the main relevance of the sternum rub is it was a method that the trooper was familiar with that is used to wake people who are otherwise extraordinarily difficult to wake. There was plenty of evidence that he had attempted shouting, shaking the defendant on the shoulder. And so he had already attempted other lesser means of waking the defendant from his sleep, and those were unsuccessful, so that warrants the inference that the defendant was passed out due to intoxication, which is then, that's especially true in light of the fact that the defendant is obviously under the influence of alcohol when he wakes up. The evidence is clearly sufficient that he is under the influence, and rather notably under the influence, serious odor of an alcoholic beverage, slurred speech, bloodshot eyes, fails field sobriety tests, unable to produce his license when initially asked, produces something else instead, claims he can't find his wallet despite the fact that it's right there. He's very obviously under the influence of alcohol, so it's reasonable to infer that he is in fact passed out because of that alcohol intoxication.
And the defendant said that he didn't have a medical issue, right?
That's correct. So then the real question is whether the evidence is sufficient to warrant the inference that he was under the influence while he drove, rather than came to be under the influence while he was at the side of the road. And again, the fact that the vehicle is out of gas, that is strange. It suggests some level, at least, of inattentiveness. That may not be the only conclusion that may be reached, but that is a reasonable inference that the jury could make, and therefore should be made in assessing the evidence in the light most favorable to the Commonwealth. And there's also the fact that there is no evidence that there is alcohol in the vehicle, despite the fact that Trooper Sheehan clearly had the opportunity to look inside the vehicle. And he certainly entered the passenger compartment at least enough to shake the defendant and to perform the sternum rub, which, based on the description, I would suggest he had to stick his head into the vehicle. He's capable of seeing the interior well enough to know that the defendant is the only occupant of the vehicle. And he's also capable of seeing the interior well enough to see that there is a wallet in the cup holder in the center console. So it's reasonable to infer, given that testimony, that there's no alcohol obviously in the vehicle, in the passenger compartment where the trooper can see it. And given that, and given the jury could infer that the defendant is passed out and therefore seriously intoxicated, based upon their common sense experience of what intoxication looks like, they can infer that he's seriously intoxicated to the point of having passed out, and therefore the lack of any evidence of obvious alcohol containers, that warrants the inference that he drank most, if not all, of the alcohol at some other location. From there, it's for the jury to decide whether he was under the influence of alcohol while driving, and given the timetable, that's a perfectly reasonable inference they can make, especially since the defendant claims to have been asleep for some time when speaking with the trooper. And I believe the argument, again, the argument is not a substitute for evidence, but I believe the argument made by defense counsel at trial was something to the effect of, well, what about if he wasn't under the influence while he was driving and then started to feel it and so pulled over? But starting to feel it means starting to come under the influence of alcohol. So even if he's only under the influence of alcohol for the amount of time that it takes him to pull off the highway, and even if that is that we are therefore finding the defendant guilty for doing what is actually in these circumstances the more responsible thing, the even more responsible thing, the thing the statute is meant to encourage, is not driving at all when there is a risk of being under the influence of alcohol on a public way. So I would suggest that the evidence here is clearly sufficient to find that he was under the influence while driving from the bar to that location on the highway for at least some portion of that period, whether it was all or some. So the evidence, I would suggest the evidence is clearly sufficient under that theory. As for the other theory, the question of turning the key, there's one thing I would like to mention, and that's the question of whether or not the turning of the key is involuntary because it's in response to a direct order of Trooper Sheehan to exit the vehicle. The order Trooper Sheehan gave was get out of your vehicle. It was
And the car was already unlocked.
In the light most favorable to the Commonwealth, the car was already unlocked. Trooper Sheehan had been able to open the door, and there he had no memory of the car becoming locked again. In the light most
So
favorable
that the defendant didn't need to start the car or manipulate the ignition in order to get out.
that is in the light most favorable to the Commonwealth, yes. The car was,
When he turned the key or whatever he did with the key, did he also use the electronic open close lock on the door of the car?
he did, yes. He unlocked it, which, again, despite there being no evidence that the vehicle was locked, this serves not as he's under the, he's acting pursuant to the direct order, but he's acting contrary to the direct order because he's under the influence of alcohol. So instead of being an excuse for that, if that act of turning the key is operation, instead of being excused because it renders the act involuntary, it's actually stronger evidence that he's under the influence of alcohol, which further emphasizes the sufficiency of the evidence in the particular circumstances. I see my time is nearly up. If there are no further questions, I'd rest on my brief. Thank you.
I also want to thank you for your concession, Attorney Wendell. We always appreciate when either side is able to concede error when there was error. So thank you. I see no other questions from the panel, so we'll take the matter under advisement. I can only say families and another versus mother. I will remind counsel that the case is impounded, so please do not use any names. Just as though we were in the courtroom, the rules are the same. Each side is permitted 15 minutes. There is no rebuttal. As I understand it, counsel's child and counsel for the department will be sharing their time equally. We have read all of your materials, so please feel free to just get right into your argument. So with that, Attorney Eisenman, when you begin to speak, the timer will start.
Thank you, Your Honor. Good morning. May it please the court, Lynn Eisenman on behalf of the mother. Your Honor's mother is asking that you vacate the decree terminating her parental rights. The first issue in this case is that the Massachusetts Juvenile Court did not have jurisdiction under Chapter 209B to issue the final decree that it did. Rhode Island was the state where the child was born and was the only state in which he resided until he was removed from mother's custody directly at the hospital. The Rhode Island statute is virtually identical to the Massachusetts statute in defining what the child's home state is, particularly for a child.
Could I ask you though, I think that you did a nice job setting out the argument. Where I'm getting tripped up, I guess, is other than being born in Rhode Island, which is certainly a significant event, that's really the child's only contact with the state. And so then I look to what the Rhode Island equivalent to our DCF did, and they notified Massachusetts. I know we don't have the judge from Rhode Island and the judge from Massachusetts conferring and deciding who was going to exercise jurisdiction, but what, if anything, can we infer from the Rhode Island DCF equivalent, their referral to Massachusetts?
So the way that seems to have worked from what is in the record is that the Rhode Island DCYF just contacted the social worker in Massachusetts directly. So it wasn't that a 51A or whatever the Rhode Island equivalent is was filed in Rhode Island. The Rhode Island social worker didn't file a 51A in Massachusetts. I'm not sure that they would have the ability to, but there wasn't a 51A filed at the time when that contact between Rhode Island and Massachusetts was made. So I think it was just, there was a disclosure by mom when she was at the hospital that she had Massachusetts DCF involvement, and that's why the phone call was made. Now,
Why?
Why was the phone call made?
Yes, for what purpose?
It's not entirely clear what is in the social worker's affidavit that was filed with the care and protection petition was just because mom had disclosed at the hospital that she had Massachusetts DCF involvement. So it seems to be that Rhode Island was just letting Massachusetts know that there was now this newborn in Rhode Island with a mother who had involvement with the Massachusetts department.
Does it matter that there's some argument in the brief that mom intentionally tried to conceal the pregnancy and purposely drove into Rhode Island to have the baby so as to avoid the Massachusetts DCF? Does that make a difference to our analysis?
So on jurisdiction, I don't believe so, and at least initially, because the child was born in Rhode Island. And certainly I will say that the arguments raised by my brother and sister in their briefs are arguments that go to whether Rhode Island should have relinquished jurisdiction and Massachusetts was maybe the more appropriate forum. But at least from an initial perspective, it was the Rhode Island court that had jurisdiction with the child being born there.
Can you infer that they're relinquishing jurisdiction by calling the Mass DCF?
I don't believe you can, because I don't think that the Rhode Island DCYF can, I think that's a question for the Rhode Island court, not for Rhode Island DCYF to say, we're not taking jurisdiction, because it's a court issue as opposed to an agency issue.
Why would Rhode Island have jurisdiction?
Because under its definition of home state for a child, given that he was less than 6 months old, it's where he had lived since birth with a parent or equivalent of a parent, the way it's defined in the statute. He was only in the hospital. It's the only place he had ever lived with mom. Mom was in the hospital with him at the time that he was removed.
So earlier, I think in your argument, you used the word resided, where the child had resided. I understand that the statute uses the word lived, but is it your client's view that that needs to be literally where that person drew breath for the period of time that they were alive, that would be enough for the purposes of the statute to confer jurisdiction and home state?
So I am corrected. In looking at the actual statute from Rhode Island, the word is lived. So it's where the child lived from birth with a parent. So yes, I think he had not been discharged from the hospital and he was still in Rhode Island. And that is by definition of the Rhode Island statute, which again is equivalent to the Massachusetts statute in that regard, because he was living there at that time of his removal. It was the Rhode Island courts that actually had jurisdiction.
How does that square with the purposes of the statute, which are to ensure essentially, and I'm paraphrasing, but I think it's adoption of Brandon, that says the purposes of the statute are to ensure that the state that has the contacts and interest in that child is the home state. Your client's interpretation of lived to mean literally just was alive in a particular location versus lived in the sense of resided or was domiciled in. How does your client's interpretation square with that?
Well, I think that if Rhode Island, so let's say the social worker in the hospital, if that social worker had concerns about mother's care of this child, or after talking with the Massachusetts DCF social worker had concerns, then Rhode Island could have filed and taken whatever necessary steps they needed to in their state court. It is troubling to me and my client that the Massachusetts DCF social worker went across the state lines to Rhode Island and removed this child and brought him back to Massachusetts. And I suggest some of that was just convenience because it was a neighboring state. I think that if this child was in, say, California or Texas or a non-neighboring state, I think the argument looks or sounds different from the department because they would have to get on a plane to make this happen. Whereas they just, drove about an hour, picked up this child and then brought him to Massachusetts. And then eventually 2 days later, filed the care and protection petition in the juvenile court.
I can appreciate that, but there's no evidence of any kind of a tie between either the mother or the child to Rhode Island. Am I right about that?
Correct. And I think that, again, that goes to the arguments that my brother and sister make about whether Massachusetts was perhaps eventually, after making an emergency order, whether they were the more appropriate forum after consultation between the two courts. But at least from an initial perspective, which court had jurisdiction.
Does it matter that, we wouldn't say that mother lived in Rhode Island at the time she gave birth, right? We'd say
Correct.
mothers lived from Fall River, I think, or certainly Massachusetts.
Correct, yes.
And yet, although mother lives in Massachusetts, because she happened to give birth in Rhode Island, then child lives in Rhode Island.
So the way that the statutes are written, the home state, which is what really controls, is all defined based off of where the child lives. And there's certainly some provisions in the statute that are affected by where the parents live and whether the child was temporarily in the state or not. But when a child is less than 6 months old, the way that the home state is defined is where the child lived.
I want to go back to something that Justice Desmond asked you about. And as I understand it, you don't make an argument that this finding is clearly erroneous, and this is finding 21, where the judge found that the mother hid her pregnancy, crossed into Rhode Island to give birth in a deliberate effort to avoid the likely prospect of losing her third child to DCF. How does that finding, if at all, play into the jurisdictional argument, particularly where you cannot waive consent or confer jurisdiction?
I think it goes to whether Rhode Island should or could have relinquished jurisdiction and that communication between the state courts at a subsequent.
So you feel like they skipped a step?
Correct. Yes. Yes. That there had to be that consultation between the judges.
Now, your sister in her brief at pages 23 and 24 from the department talks about the statute in Rhode Island 15-14.2 little I, and says that Rhode Island does not have jurisdiction if a court of another state has it, and where the child and the child's parents do not have a significant connection, there's no substantial evidence concerning the child's care, protection, training, and personal relationships. We give full faith and credit, right, to that Rhode Island statute. And so I understand your argument is they skipped a step, but when I look at the Rhode Island statute, it seems pretty clear that Rhode Island did not have jurisdiction under the home state as it defines it.
Well, I think that is, again,
maybe the question is, did the child have any home state?
I think that he did have the home state of Rhode Island because that's where he was born. And granted, he only lived in the hospital and it was only for several days.
Do we have any cases that talk about home state in this particular scenario where the child is days old and has only been in a hospital in a different jurisdiction?
I could not find any. A lot, most.
For example, if it's not the case, fortunately, here, but if the child needed some unique medical attention and the only place that you could get it was at this Rhode Island hospital, and the family voluntarily brought the child there or had the baby there because of the unique neonatology needs, you wouldn't make the argument that because of the medical emergency that Rhode Island was the home state, would you?
I think there's two different scenarios as to whether the child is born in a state or taken to a state for specific treatment. So if the child is taken to a state for treatment, that state he's originally from arguably is his home state, presuming he's lived there for either 6 months or was born there.
Right.
But I think that if the child is born in that state, that's where his home state is.
Do you have any case where a judge from one state, is it your position that a judge from one state should have gone on the phone to a judge from another state and said, hey, you guys take jurisdiction? And do you have a case where that has happened?
Yes, so that's exactly my position, that they should have consulted with each other. So adoption of bill is a case that I cited in my brief where that communication happened, and that's a jurisdictional case where the child was coming from California. You know, and again, perhaps it was that, or would be that Rhode Island would relinquish jurisdiction because of the close contacts in Massachusetts. But the crux of the argument is that that step was skipped. And because
the act provides for that as well.
It does, yes. The Massachusetts statute specifically provides for that. And I don't have it right in front of me, but I have to presume that the Rhode Island statute provides for that as well, since they're similarly drafted.
Could I switch topics just for a minute and
Yes.
ask about two areas that you raised, to ask if they had been raised below or if they're being raised for the first time on appeal. And the first is the procedural argument that you make concerning the timing of the notices issue. Was that anything that was raised before the appeal?
Of the notice of intent?
There's an argument that the department failed to follow the time requirements for the issuance of various steps of the process.
Right. No, so that was not raised. Right. That was not raised below. And I did acknowledge that in my brief. I just wanted to set the stage for kind of how this case came to be.
Okay. And second, the issue of the judge's consideration of what your client is terming the father's juvenile probation record under 11960, was that raised below any aspect of the consideration of the father's juvenile history?
Not specifically the father's juvenile history. There were motions in limine that were filed with rulings on that the guide to evidence and rule 1115 would be specifically followed. So from that perspective, that's the reliance that I take on that position. Okay. I see that my time is running low. So just the other major issue that I would ask the panel to focus on would be the lack of a nexus between the primary issues that were, or concerns identified about mother, specifically her mental health, her substance use, and whatever form of the relationship she did have with the child's putative father. And I did outline it in my brief that there is no connection between those alleged concerns and her ability to take care of the child. She demonstrated her ability to care for this child during visits. That was the only time she really had to be able to care for him. And she did a very good job according to the record. And I think the judge even put on the record that the visits did go very well. So if there are no other questions, I would rest on my brief.
I don't see any. Thank you very much. Attorney Kipp, are you going first? All right, if you could turn your mute button. You're still muted. There we go. Okay. When you're ready.
Good morning, Your Honors. Carrie Kipp Horseman on behalf of the Department of Children and Families. If I may first just briefly address Justice Hand's quick question around the issue of the evidence regarding father's violent criminal behavior occurring when he was a juvenile. As my sister counsel concedes today, that objection, the objection she raises on appeal, was not raised below and need not be considered, it should not be considered by this court at this juncture. The issue of whether whether the evidence of father's activities, his criminal activities occurring when he was a juvenile, those are not prohibited under Chapter 119, Section 60. If you read that statute, it talks about utilizing that evidence against that child. The child would be father. In this case, father was not a party to this case. He had been stricken early on. So at the time of trial, he wasn't a party, and the evidence was not being presented as against him. Rather, the court was considering it as it was required to do. It was considering it in conjunction with its assessment of the risk of harm to the child should he be returned to the mother's care. And certainly, given mother's ongoing and longstanding relationship with the father, information about his violent past and more recent information as well is certainly relevant to mother's ability to protect and safely care for this child. So where it was not raised below and where the statute doesn't apply in this case anyway, I would ask the court to affirm the department's argument in that regard. Turning to the issue of jurisdiction, I would like to just follow up on I think it was Justice Desmond's comment about taking the word lived very literally. It's the department's position that the Commonwealth does have jurisdiction in this case. And the fact that, as Your Honor said, the courts may have sort of skipped a step in terms of not filing in Rhode Island and then having the judges confer with each other and refiling in Massachusetts. That wasn't necessary in this case.
Well, but normally, right, you would have had a petition filed in Rhode Island, perhaps or perhaps first an emergency petition asking Massachusetts to take emergency jurisdiction, and there's an arguable reason why they would have done that. Then the petition in Rhode Island, then the required call, and then there would be a decision. I recognize that this child was just days old, but you can't consent or confer jurisdiction. So missing that step is pretty significant.
Respectfully, the department does not agree that that step was necessary in this case because
Why?
Because Rhode Island never had jurisdiction over this case. As I think it was Justice Desmond alluded to, the fact that mother went to Rhode Island just for the purpose of giving birth to this child so as to attempt to avoid further intervention by DCF does not mean that the child lived there. Certainly the mother still lived in Massachusetts. And as the department cited in its brief, cases like adoption of Daphne, which is a 2020 SJC case, talks about and clarifies the fact that a child's domicile is the same as the parent's domicile. So if mother still lived in Massachusetts, the child lived in Massachusetts as well, and he doesn't qualify as being a resident of Rhode Island for purposes.
But is domicile the same as home state?
That's unclear, to be honest. I think the terms lived, domiciled, resided are not entirely clear. But if you read this in conjunction with, as Justice Hand said, the purpose of this legislation is to serve the best interests of the child and to confer jurisdiction or to have jurisdiction lie in a place that makes the most sense and is in the best interest of the child. Here, there can be no doubt that the significant connections and all of the substantial evidence is in Massachusetts.
So I'm trying to understand, are you saying that Massachusetts was the home state or that the child had no home state at the time?
It's the department's position that the child had no home state at the time.
So then Anisha would control.
Exactly. I was just about to cite to Anisha, which is a case where mother gave birth en route from Maine to her home in Massachusetts. She gave birth in New Hampshire. She then absconded to another state with the child after that. New Hampshire didn't have jurisdiction over this child or this case just because he was born there. The court specifically said in Anisha, this child had no home state. And as a result, the Commonwealth properly had jurisdiction over the child's care and protection. So I think that this case is more in line with Anisha, with some clarification from the SJC in adoption of Daphne. And again, referring to the Brandon case in terms of looking at all of these statutes in context and looking at the legislative intent behind them. I think in terms of legislative intent, we can also look to General Laws, Chapter 119. It's in Section 24 that talks about, where a care and protection can be filed and where jurisdiction lies. And it says where the child is located or where the parent is domiciled. So in Massachusetts, if you read Section 24 in conjunction with the MCCJA, it's clear that the child's, that jurisdiction over this child was proper in Massachusetts, and the cumbersome but sometimes necessary process of having the judges confer and having two different cases be filed when there was already an open case on this child's siblings in Massachusetts didn't make sense and was not in violation of the MCCJA. If the panel doesn't have any further questions, I will cede the remainder of my time to Child's Counsel, such that it is.
Seeing none, Attorney McCarthy, when you're ready.
Thank you, Your Honor.
Yes. Good morning, Justices Blake, Desmond, and Hand, and fellow counsel. At the outset, the child would just like to point out that he's been in the same home since he was about 4 weeks old. So this home that he's in is the only home that he's ever known. To put that in some type of perspective, the child is about 4 years old now, and he's been in the custody of DCF for virtually his entire life. The plan for the child is adoption. He's attached to the pre-adoptive family. The pre-adoptive family is attached to him. The judge pointed out in its findings that the mother had about 586 days from the time the case was filed to do what she needed to do in order to try to attempt to get the child back, and she failed to do that. Now, childhood is fleeting, and 586 days is a long time for a child to wait, or for anyone to wait for permanence. And sometimes the judge just has to say enough is enough, and that's what the judge said in this case. And the child agrees that termination of parental rights was the right thing to do. The other thing is the mother must have been aware of the seriousness of the matter, because she lost 2 kids to a prior care and protection case. And that care and protection case was filed about 2 months after the current case that we're talking about today was filed. So she must have had some idea of the seriousness of the matter that was before the court and that she was facing.
Attorney McCarthy, do you agree with Attorney Kipp that the child had no home state?
I do agree with that, but what the child would like to emphasize is all the players in this case were from Massachusetts. The mother, the putative father, their family, everybody was from Massachusetts. The judge said that the mother went to Rhode Island to try to evade the jurisdiction of the Massachusetts court. The only thing that would happen if this case was dismissed, because I think that's what probably would have to happen if there was no jurisdiction, is that we would start the process all over again. Mother hasn't shown any kind of momentum as far as getting her act together to follow her service plan, to do what she needed to do. And it also would kind of give parents an incentive that in order to evade Massachusetts jurisdiction, that all they have to do is have a baby in Rhode Island or New Hampshire or New York. And that generally wouldn't be in kids or children's best interest, especially infants. And in this case, all the information that Massachusetts had was used to protect this child. So I think we have to look at this from a different perspective as far as what would be the effect for mother if it was dismissed. She would have to do the whole proceeding over again. The child would have to wait probably another couple of years in order for this case to cycle through the juvenile court and probably the appeals court. So that's the child's perspective on that. But mother claims that the findings don't demonstrate by clear and convincing evidence that she was unfit. And there was the judge listed multiple factors as to why the mother was unfit. She was involved in the criminal justice system here in Massachusetts. She was involved in domestic violence with a putative father. She had housing issues. She abused marijuana. She had mental health issues, and she didn't comply with her action plan.
Was there evidence that in the trial that she was gang involved?
Well, there was evidence that at the toward the end of the trial, toward the end of the case, about a month before trial, mother was involved in therapy. But before that period of time, mother wasn't involved in therapy. She went to therapy whenever she felt like it.
I'm not sure if you misheard my question because of Zoom. I was asking about her being involved with a gang, G-A-N-G.
Oh, yes. And what was the question about the gang?
What was she gang involved? Did the judge make a finding about that?
There was evidence that she was gang involved, and there was evidence that her brother that she lived with the rest of her siblings, was gang involved. And there was evidence that the putative father was gang involved also, and the judge took that into consideration, the juvenile court judge.
And mother had been stabbed. When was she stabbed relative to this child's date of birth?
I'm not positive when she was stabbed. I don't recall. I do recall she was stabbed, and I do recall that the judge mentioned something about gang involvement and mother's using marijuana, or the gang that she was with using marijuana. So there was gang involvement, there was marijuana use, and mother did have a severe marijuana problem. She abused marijuana, and there was a nexus between her marijuana use and her ability to take care of the child. She smoked marijuana from the minute she got up in the morning, and then she smoked throughout the day. She went to a couple of visits smelling like marijuana. There was evidence that she said that she did smoke marijuana before one of the visits. She self-treated her mental health injuries, her mental health issues, I should say, with marijuana. And she was on probation, and part of the terms of probation was for her not to use marijuana. So she was in danger of being violated for that probation, and she could have went back to jail. So this is not a mother or parent that is putting a child's needs before their own needs.
Your client was born in 2017, and according to the judge's finding 35, mother was stabbed in August of 2018. Is that the right timeline? Your client's date of birth is 2017.
He was born in 2017. He's almost 4 years old. So there was evidence of gang involvement, and that you, Judge Blake, you correctly pointed out one of those instances, and the judge didn't find criminal fault, mother at criminal fault for that incident, but she was in the wrong place at the wrong time because of her associations. And as far as domestic violence is concerned, I see my time. I can't actually see my time.
I think we're gonna have to leave it at that. I know that you have that addressed in your brief. Counsel, yes. Thank you all. These are always very difficult cases, and we appreciate.
And we are back live and on the record.
Thank you so much. Our next case is 2020P0342, John Morse versus Jorge ORTIZ-VAZQUEZ. Good morning, counsel. Let me introduce the panel. My name is Amy Blake, and I'm pleased today to be sitting with Justice Kenneth Desmond and Justice Catherine Hand. Although we're doing this on the Zoom platform, we will proceed as though we were in the courtroom, so each side is permitted 15 minutes of argument. There is no rebuttal. We have read all of your materials. We also had a discussion before we went live about how we're going to handle the amicus, and we're going to allow Attorney Higginshea 2 weeks to file a responsive pleading, and then give Attorney Strauss 2 weeks thereafter to either tell us he won't be filing anything additional or to file something additional, and then the record will be complete at that time. So as soon as Attorney Higginshea, as soon as you begin speaking, the timer will start. So when you're ready.
So I think, again, thank you. And it's important to start with the fact that this isn't Mr. ORTIZ-VAZQUEZ's first summary process case. The case that's before you was brought on the heels of a second case which resulted in a trial in December of 2000.
Actually, I'm going to stop you. I made a mistake this morning. I believe that it's Attorney Strauss that's the appellant, so I apologize.
I went with you.
You all need to keep me on my toes better than that. I apologize. I do.
I was just following instruction. I thought it was.
You know, I appreciate that. I think I got confused because on the pleadings, you all flipped the names. So I do apologize. Maura, I apologize to you on the timer as well. So actually, we'll do that again, but with Attorney Strauss. I do apologize.
We've broken the ice now.
There we go. All right, Attorney Strauss, you are the appellant, so you may proceed.
Thank you, Your Honors, and good morning. Uri Strauss for the defendant and appellant Jorge Ortiz-VAZQUEZ. May it please the court. Rule 10 of the Uniform Summary Process Rules prohibits defaulting a defendant who appears for trial, even if he does not file a timely answer. The rules, the case law, and public policy all favor the conclusion that a defendant who appears for trial must be heard on his defenses, and the judge's decision to the contrary was an error of law. But if it was an error of law, it was nevertheless abuse of discretion, should be reversed for that reason.
Can I ask you this? Is your argument the same as between the affirmative defenses and the counterclaims, or should we consider those separately?
Well, the rules are separate. There are no counterclaims asserted in this case. And
but
part
the
of my,
judge goes on at some length in her colloquy or her discussion with counsel about leaving open the ability of your client to file counterclaims, but then she talks about there not being any pleading in which to do so. So what's the functional equivalent of going forward on counterclaims? Would he just have to file his own complaint?
yeah, that would be it. As she made clear, she was not going to entertain any defense or counterclaim as a grounds for retaining possession as a defense, and he was free to either file a separate case on the counterclaims, or as she suggested, perhaps try the counterclaims, but not have them affect possession.
So is your argument more towards the affirmative defenses or the counterclaims, or both?
Just the defenses. He was not seeking to assert counterclaims in this case.
Okay.
Is there another question?
Although you argue it's akin to default, it's clearly not a default. I mean, there was a trial in this matter. Would you agree?
There was a trial, yes.
And although it was stipulated, or your client stipulated to many facets of it, there was indeed a trial. He had his day in court, so to speak.
He had his day in court, but he didn't have it on the full merits of the case. So I would maintain that it is a default, because a default is when the defendant doesn't get to be heard on the merits of the case. And I would say that that means the full merits, and that when the judge arbitrarily chooses which type of defense is permitted, affirmative or denial of the plaintiff's case, and allows one but not the other, then that's a default. But I don't know the definition of default. I couldn't find one. So really what I'm trying to establish is that based on the structure of the rules, Rule 10, which uses the word default, but the overall structure of the rules and other reasons, as a matter of law, affirmative defenses should have been permitted. And if it's not called default and it's just called something else, that's okay by me.
Okay. Do you agree that as a matter of law, your client's not entitled to file a late answer as a matter of right?
I'm not sure whether I agree. That the important thing for my client is that he's entitled as a matter of law to assert affirmative defenses. It may be within the judge's discretion whether the judge would want that in the form of an answer, or the judge would simply permit it to be asserted at trial without having an answer. I think the way the rules are set up, they permit a late answer, but I'm not married to that, and I don't think my client has to prove that. The important thing is the affirmative defenses.
If your client had been permitted to put on affirmative defenses, but without the benefit of the issue of possession potentially going in his favor, would that have changed your client's position?
Well, no, because he sought to assert a defense to possession specifically.
Okay.
And I believe he had the right to do that, because no defenses could be arbitrarily taken away just for filing a late answer, and as long as he appears for trial. The rules really focus unlike the civil rules generally, in which default and whether one can raise defenses really depends on the timeliness of the answer. In the summary process rules, it's really about whether you show up on the day of trial or not.
And when your client showed up on the day of trial, was he prepared to go forward with the affirmative defenses in a way that if the affirmative defenses had not been precluded, would he have been able, on the evidence that he brought with him to trial, to go forward on those?
Yes, and that's true both both on the original trial date and postponed date eventually, where the judge made remarks to the effect that she saw that he came prepared, that he brought photos with him, and remarked that she didn't understand why he did, because her order should have been clear that he was not permitted to assert defenses. So yes, he would have been prepared to go forward.
But did he have a witness who is, and I'm sorry if this is going down a rabbit hole, but did your client have a witness available to facilitate the introduction of those photos and the mold report that he brought with him?
He did not, which is why he asked for a continuance. I would maintain that he would not necessarily have to have the witness there. And I would note that in the previous case in which he prevailed, he showed up by himself and presented testimony about the same issue, mold, and prevailed in front of the judge in that case. So to the extent I think, okay, if that answers your question.
It does, thanks.
Thank you.
For the timeline with you, Attorney Strauss, because the answer would have been due March 18th, 2019.
Mm-hmm.
The hearing date was scheduled for March 21st. That's when he filed his motion to file answer late, which was denied. The first trial then got moved till April 4th. And at the time that, I want to make sure I'm right, at the time that he argued his motion to file a late answer, the landlord at that point did not object to a 2-week continuance. Is that right?
That's correct.
And then why did the case get rescheduled, if it's in the record, from April 4th to May 31st?
It was a bit of a quagmire. So apparently the court never recorded on its calendar that trial was on April 4th. My client recorded it on a piece of paper, which he lost, and thought he remembered it was April 5th. So the plaintiff showed up on April 4th, asked for the file to be brought up from the clerk's office, and asked for a default, which they got. My client showed up on the 5th, asked to remove the default, and before Judge Fields got a favorable decision which removed the default. I would note, since I'm talking about that Judge Fields did in his order note that the plaintiff believed that the initial order, which denied an answer, meant that he could not present affirmative defenses at trial. Judge Fields believed that did not necessarily follow, and invited the plaintiff to bring that in a motion on day prior to trial, which did not happen, which to some extent justifies my client then showing up pro se on May 31st, again preparing to present his evidence.
Judge Fields was the trial judge from the first trial?
He was the trial judge in the first trial, and he was the judge on the motion to vacate only in this trial. Otherwise, it was Judge Fine. If that clarifies the timeline, I'd just like to proceed to talk a little bit about the policy that animates the summary process rule. And a lot of this refers to the amicus brief, which I expect now will be admitted, so I'll refer to that. The summary process rules, as the brief shows, are rules for pro se people, especially defendants, and they should not be read to potentially permit many, many people to default. Because what the brief shows in a sampling study is that summary process defendants are overwhelmingly pro se, overwhelmingly don't file timely answers, but they're permitted by the courts either to file late answers containing defenses or to defend their cases without filing any answer at all.
Can we stray a bit from the default question and look at it under an abuse of discretion standard? And I'd like you to clarify for me what your view is with respect to the excusable neglect and the good cause standard. what standard do you think Judge Fine applied and what standard she should have applied?
Well, I think she applied the standard for motions to vacate default. I think I have specific words here. I may not have her specific words right in front of me, but what she said was that the plaintiff, that the moving party needs to show A, that he had something to say, meaning that there was some merit to his case, and B, that he had a good reason for missing his deadline. And that's essentially the standard for a motion to vacate default in the civil rules. And that is too harsh of a standard for a situation where default would not be permitted in the first place. So whatever the standard is, it needs to be more lenient than the already very lenient standard for vacating a default.
Do you agree that the notices are in Spanish?
I think the summary process notice says something about translating it into Spanish. I don't think the notice itself was in Spanish.
Because your client's position is essentially, because of my language barrier, I can't be held to the rules.
Well, his position is that one of the reasons he didn't file the answer on time, apart from his general lack of understanding of the process, was that him perhaps especially didn't understand the process because the notice was in English and he spoke Spanish.
Right, but at page 18 of the record, it's translated into Spanish that if you do not file and serve an answer, or if you do not defend at the time of the hearing, judgment may be entered against you for possession and the rent as requested. So there is that piece that is translated into Spanish, which is the second page of the summons and complaint.
It is. Yeah, it is. I would note that the overwhelming number of people, even English-speaking tenants, don't file timely answers, and there's a lot of reasons for that. And I'm not suggesting that he be uniquely excused because he doesn't speak English. I'm suggesting that that was one reason among several that he did not understand, that he failed to file the answer on time. And I think even if he had totally understood it, I think the rules, simply as a matter of law, permit the late answer to be filed and the defenses to be asserted.
So I think this question could go both ways, and I'm likely going to ask the same of Attorney Higgins-Shea, but at page 66 of the transcript, or 66 of the record, page 9 of the transcript, Judge Fine has a discussion with Attorney Higgins-Shea that she's prepared to defend the conditions claim, and she's brought witnesses, and then there's sort of this discussion about prejudice to her because she has these witnesses here, they've taken time out of work and the like. It's not a frivolous argument to me to suggest that she would be prejudiced because she's had witnesses there, they're ready to go, it's time is money and the clock is ticking. So what do you say about that?
Well, she could have proceeded the same day, and I did ask the judge for a continuance, but it was within the judge's discretion to deny it. So under Rule 10, if the defendant shows up not having filed an answer, the landlord's options are ask for a 1-week continuance or proceed the same day. So that could have happened. So that goes to the question of whether a delay, whether a postponement ought to be granted, but it was agreed to in this case. So I think that eliminates any argument that there was prejudice. I would add that my client, as the appendix makes clear, absolutely advised the landlord before the case was even filed, after the notice to quit was sent, what his issue was, which was conditions. In fact, he handed him a report with details about the mold and mildew conditions. So there's no element of surprise in this case either.
It seems the judge was essentially saying that, you were permitted to file a late answer to the first trial. Because of that, you were aware that there's timelines imposed, and so you should have known. So to say that, well, I filed a late, again, I'd like to file a late notice because of a language barrier. She just felt that was not fundamentally fair to the landlord in this particular instance. Is there something that's unreasonable about that analysis?
Well, if we're in the realm of abuse of discretion, in the first place, I would say that there were witnesses there ready to testify. My client could have testified about his state of mind and his lack of understanding, but the judge, because of the surprising nature of the ruling, did not invite testimony. So she really had no insight into his state of mind, and any conclusions that were drawn were just based on characterization of counsel or based on the record of the prior case. So I do think it's a little bit unfair. I
want you to complete your answer, but then we're going to have to leave it there.
Yeah, so I would just say that his whatever happened in the first case, it was contested by counsel, whether he obtained an understanding, and that the judge later indicates that she did not conclude that he knew that he knew the answer deadline, merely that he knew or should have known the answer deadline. So
let me see if the panel has any additional questions. All right, seeing none. This time for real, Attorney Higgins-Shea. Oh, you're still on mute.
There we go.
Okay.
Sorry about that. So I think you've highlighted some of the important factors, one of which is this was not the first summary process case. This was brought on the heels of another case, same parties, same fact pattern, and same procedural inaction by Mr. ORTIZ-VAZQUEZ. It's that missed deadline of that's called for in Rule 3. Can
I ask you though this? I mean, it troubles me that 1 month after he successfully defends for possession, we're back with the same mold issue. That's troubling to me.
Well, what this record doesn't show, and what you would know from the first trial, is that I had in my bag of evidence, I had a letter of compliance from the city of Springfield, which issued right before my December 2018 trial. What I also had in my bag of evidence, if you will, was a mold report from a mold expert that my client retained, which is alluded to in the record, and as I responded to the judge's questioning, was that there isn't mold. There was no such mold experts or mold reports in the first trial.
So the materials that the tenant brought with him on what ultimately turned out to be the trial date of May 31st, there were photographs and there was a report. Are you saying that it wasn't a timely report in terms of the timeline of the repairs or remediation on this property?
I would tell you that I believe, and this is memory, his report was from January. It was handed to my client's property manager after he got the notice to quit. Okay. My client got its own expert. I believe that was in March of 2019, right before our original trial date.
So let me ask you if I could, and I thinking about this more for these questions under an abuse of discretion standard than the default question. Sure. I give you credit. You did not object to the 2-week continuance, and even on May 31st, you told the judge at page 9 of the transcript 66 of the appendix that you were prepared to go forward even on his claims. She took the action she took, and I appreciate that you had witnesses there that were being time out of work or needed to be paid and whatnot, but particularly where you had initially agreed to a continuance and were prepared to go forward on his affirmative defenses if she had allowed them that morning. Why didn't she abuse her discretion in not permitting the affirmative defenses? You were ready to go.
So the judge, the housing court judges, like all others, have broad discretion. And This is an exact example of that. Is that Rule 3 calls for an answer being filed by a certain date, certain time, and that didn't happen. And I think that that's totally within her authority, and she exercised that discretion after considering the history, after considering what had played out that morning of that May 31st date. I mean, the nature of summary process is supposed to be quick moving and efficient. And I think that's what she was sticking to, is keeping this case moving forward.
She said something at page 71 of the appendix, it's page 14 of the transcript, that, and this is when she was explaining her ruling, I think after your brother counsel made it clear that this might be going up. And she said at line 14, "It would not surprise me if Mr. Ortiz-Vasquez finds himself here today not really understanding anything that's happened." When we're looking again at discretion, how does that statement by the judge, and in fairness, she says that's not your fault, that's the court's fault, but that's a pretty striking statement to me.
So I'm cognizant of that, but I would say is that this process hadn't changed.
From the first trial.
Oh yeah, this is the exact same procedural pattern, that he gets the notice to quit, he gets the summary process writ, the case gets filed, there's an answer date, and there's a trial date, and he shows up and he files that answer on the trial date. It's exactly the same fact pattern. I understand that perhaps, and I think maybe if you drill that down a little bit, we spent, and Attorney Strauss probably recalls, I think we were in that courtroom for 3.5 hours that morning. And I take that as maybe not understanding how things played out that morning, or why we're at the point we're at, and why it was taking so long. I mean, I had three witnesses with me that morning that, despite being represented by counsel, weren't even sure what was going to happen next. That's the way I take that statement.
Why isn't this tantamount to a default, striking the affirmative defenses?
So Rule 10 says that if he shows up and hadn't filed an answer, or had that motion to file a late answer denied, that it proceeds to trial. And at that trial, it was my client's burden to prove his case, to prove that he gave a notice, that he gave the right notice, that the notice that he sent was received.
And all of that ultimately was stipulated to.
It was, and it doesn't always happen that way. I mean, I've had trials where the receipt of the notice is contested. I've had trials where the amount of rent owed is contested, and you walk your client through, or you walk the property manager through what payments were made, what payments became due. I've had an unsuccessful trial where receipt of the notice was the issue, and the judge, the same trial judge, ruled against my client that the notice had not been received. Those elements have to be proved for my client to be successful. And in the brief reading of the amicus brief, there were some of those cases where the landlord didn't prevail on the basics of their claim and didn't get over that hurdle. There were also cases in there, and I'll just say for the record, the little bit that I was able to drill down, there were 13 cases in there in which the defendant did not file a written answer, and it said something, and I wrote it down. I don't want to misquote what it said, but it's the trial judge noted that the defendant was allowed to testify, and then it said without objection. So what I take that to mean is somebody like me, landlord's counsel or landlord, did not object to the affirmative defenses or the counterclaims coming in. I will note there was one where it said over objection. So what happened in this case is I objected. The rules weren't followed. I still had to prove my case, and I understand entirely that it was stipulated to. I get that, but that doesn't always happen.
How does this case compare to CMJ versus Wilkerson, where we said that it was draconian to strike a jury trial demand because the pro se litigant had not complied with the pretrial notice and order?
Well, I think we still have to look at it in the discretion that the trial judge has. I will also say that this is a little different, and I think lumping this case into ones where maybe, and I don't know from the fact pattern here, whether this is the first time this person had been to housing court. I don't know if she was at all familiar with the process. I don't know if she's been there 10 times. You know, this fact pattern is different than the first time housing court litigant. This is one case on the heels of another with the same exact fact pattern, same exact parties. That's where I think it differs. I read the case actually again this morning, and I don't know whether this was someone that had been to court in another case or been to court at all in any other case. But I can tell you, being involved in the 2018 summary process case, Mr. ORTIZ-VAZQUEZ had a trial, did a trial with me, almost a full day trial in front of Judge Fields. So, I mean, I get that he's pro se, and I am not disputing in one way, shape, or form that that's not an important factor when the court's using its discretion. However, this is I've spent, it feels like a year with these two cases.
It sounds like some of the arguments made by your brother are policy arguments. Should they be made to us?
So, Your Honor, I think probably it's more of a legislative change. I think if you're taking the rules on their face, if you're taking the summary process rules on their face, an answer is due by a certain date. And that wasn't complied with here. And the judge, under the law, that law and the power and the authority that she has, exercised her discretion. And considering that 2018 case, considering the needs of the parties, considering, in fairness to both parties. But I think there is some policy argument behind it, because, the fact of the matter, and I think we'll all agree, is that in most housing court cases, the tenant is pro se. But that's not to say there isn't resources out there. I mean, in this particular circumstance, Community Legal Aid, Attorney Strauss's organization, stepped up to help. That's what these services are there for. Should I keep on going?
You still have 3 minutes.
Oh, right. Just look back through my notes. Yeah, I think I would just emphasize, and I know we've asked and it's been answered, the fact that I still had a case to prove. So a default at him not filing an answer and not having that motion allowed, I still had to get in my case. I still had to prove my case. And if he hadn't stipulated to all that, I still had to prove all the elements to get me in. And that doesn't always happen, as I said. So I think it wasn't a default. I think under Rule 10, he was afforded a trial at which I had to prove my case, and that the judge, using her discretion, decided not to continue continue the trial at counsel's request. I will say, in part of that, and we noted the witnesses that I had there, I had those same witnesses there like 3 times over. I had the witnesses there on that April 4th date. I had the witnesses there because I didn't know whether after that motion to remove a default, if it was allowed, if we were going to go to trial, I had them there then. And I had them there on May 31st. So, I mean, I still had to do my job if that's what the court was going to direct me to do, and I still had to prove my client's case. Again, and I can't emphasize enough, I think the trial judge has broad discretion to make rulings in a fair and equitable way to all the parties. And she took into account the fact that Mr. Ortiz-VAZQUEZ was pro se. She took into account the fact that my client had been there 3 or 4 times over to try to get to their trial date, and took into account that language barrier. It is, and as you pointed out, the forms that the housing courts sends out, they do have notices in Spanish on them as well. So in closing, I think that the judge did not abuse her discretion. I think it was within her discretion to make the ruling she did.
I don't see any other questions from the panel, so we will take the matter under advisement.
And we are back live and on the record.
All right, and our last case of the morning is 2020P0016, Franz Steiner versus Kathleen Steiner. Let me introduce the panel. My name is Amy Blake. I am pleased today to be sitting with Justice Kenneth Desmond and Justice Catherine Hand. The rules are the same as they would be if we were in court, so each side is permitted 15 minutes. There is no rebuttal. We have read all of your case materials, so you should feel free to get right to the argument. And as I understand it, Attorney Hebert, you are the appellant. So when you begin, the clock will appear and take it away.
Certainly. Good morning, Justices. May it please the court. Mandy Hebert on behalf of Kathleen Steiner, the appellant. In this particular case, what we're dealing with are 2 major issues. Issue number 1 is whether the court properly considered Mass General Law 208, Section 53A factors when entering in a judgment for alimony.
Can I ask you, I know that Judge Amelia didn't use sort of the magic words, if you will, about ability to pay and need. But when I look at her findings and she sets forth what she says the income is and what she says the expenses are, and those are both adjusted numbers based on a variety of things. And this is at Section F, the needs of the parties, and Section M, alimony. Why, when we read that together, can we not say that she has addressed the ability to pay and need?
Well, first of all, because the 2 statements contradict each other. In the need section, where the judge talks about the husband's financial statement, the judge brings up that husband credibly testified that the information on his financial statement was wrong, and then goes on in the alimony section to say that she used the financial statement, which had incorrect information, to determine the alimony award in this case. So those 2 factors completely go against each other, and they do not flow.
I don't know if I agree with you, though. If you look at M, it says that she relied on the income of the wife's as listed on the financial statement minus the pension income. And then she explains how she determined the husband's income. And she makes adjustments.
Certainly, Your Honor, Justice, I would suggest, and I'm looking at page 6 of 6
Yep.
And I'm going to where the court finds.
No.
So the court finds the testimony of the husband credible in that he has not been paying monthly rent for his personal housing for his business. The husband testified he has performed tasks for his landlord in lieu of paying rent and has credited his landlord with these tasks. There was no definitive testimony as to when the credit towards the husband's rental payments would be exhausted. So reading this language, this is ambiguous. And with respect to the financial statement, husband testified that he had, and this is, we have this pointed out in our brief, that husband had testified that actual expenses on his financial statement were wrong. He had expenses for rent, which he is not paying. He was not paying. He had an expense for rent for his home. He was not paying for those, paying for that. He had expenses for his utilities. He did not, he's not paying those. And so what happens is when we go back over to page 6 again and we look at the judge's order as it relates, she talks about the husband's income used for alimony calculation is inclusive of his disability income and his self-employment income as listed on his financial statement dated April 10th, 2019. So that was not adjusted to take into consideration all of the expenses that should have been, some of the expenses should have been gone to the income section of the financial statement. So she used and she relied on a financial statement that she earlier mentioned was not correct.
It appeared to me that there was some confusion with respect to the husband trying to answer the question about whether he was actually paying rent or whether he was doing this type of bartering system where he would work off the actual payments. And I think the court touched on that. Do you quarrel with that piece of it?
The court did touch on it. However, the important part is that the court said that there was no definitive testimony as to when credit toward the husband's rental payments will be exhausted. And it's very, very clear in not only Zaleski, but also Hasse, that when you're looking at a needs portion, in order for an alimony amount to comport with the 2011 alimony statute reform, you must make specific determinations as to what the needs are of the recipient spouse.
At that time,
did not happen.
Is the relevant time the need of the spouse at the time the decision is being made?
That is correct.
And didn't the judge do that here, if you accept, putting aside the disagreement that you may have about how it was reached, but her determination was made as of the time of the trial, not prospectively, correct?
Correct. That is correct, but it's not clear. It's not clear that she made a determination as to his specific needs. You go to the needs section and it contradicts itself. The needs section, the court credited husband's testimony regarding his expenses, even though he misrepresented those on his financial statement.
Did you file a 299 motion to clarify?
I did not, Justice. So those two components with respect to the statute. Now, again, if we go back to Zaleski, it's very, very clear that the judge has to prove, or has to show, excuse me, that they have used or all factors, or they have factored all of the 208-53A factors when making a determination for alimony. Nowhere in the judge's findings do you see any reference made to 208 section 53A. Nowhere. What instead the judge did incorrectly rely on Section 34 factors to determine the alimony judgment. Now, I understand.
Well, but in fairness, counsel, when the Reform Act was passed, 34 was amended to include as a new factor that hadn't been there before, the amount and duration of alimony. So when she says she's factored in all the factors under 208-34, and she lists some of them, by referencing the statute, she is in fact referencing the alimony statute because that's a factor under 34 now.
Right, understood. And it's very clear that these two, 208-34 and 208-53A are similar. But the court has held that you need a separate analysis for each statute. When you're looking at the alimony, there's a different analysis that you're going to put together than the distribution of the marital assets under 208-34, clearly. And again, it's not a situation where the statute's mentioned once or twice, but it's not specifically talked about on each, with each, health needs, all of that. It wasn't mentioned whatsoever. It's
if the factors are considered functionally, is that sufficient? Or is there some requirement that the statute itself be cited and each of the factors identified?
That is correct. That is what the court has held in Zaleski and also in Hasse, that it has to be clear. In Zaleski, court examined the judge's findings to determine whether the judge considered all of the relevant factors under 208-53A, all of them. We have proof. We do not have any proof that she considered any factor because the statute itself is not discussed. And again, there's no specific determination when it comes to the needs. If we also look at the judge findings that wife's ability to work in her current capacity and draw from her pension was uncertain. That is certainly not flowing logically. It's uncertain. She testified credibly that she must obtain a waiver in order to work in her current capacity. Wife testified that
this is modifiable. This is modifiable. So if this happens for your client, she can come back in and seek a reduction or a termination.
Certainly, right? That is correct. Yes, of course. But the question is whether or not it was, and again, because there was no specific determination as to his needs, we don't know whether or not it was an appropriate, and we're certainly saying it was not an appropriate. It was not an appropriate order. We have a gentleman here who's collecting disability. He's collecting his regular pay from his business. He's also collecting alimony, and he'll soon be collecting his Social Security as well. So this is a person
then about his financial statement.
Certainly.
He lists under his weekly gross income at page 2. This is at the first page of the financial record 134. I'm going to round $544 in income. Do you disagree with that number?
Yes, Your Honor, because what had happened, and that financial statement that has been provided for you, that can actually be disregarded because that doesn't have to do with the actual trial date.
Well, you put the appendix together, so I'm just using what you gave us.
I understand that, Your Honor, and that's my apology.
So this financial statement was not the trial financial statement?
That is correct. It is not.
So we don't have any financial statement from the trial in the record?
We do not know.
Okay, I don't have any other questions about that financial statement then.
One of the things that you point to, counsel, is a quarrel with how much credit the court gave your client's testimony with respect to her health issues. And you indicated in your brief that the wife testified that there was a joint agreement between husband and wife that she would retire early. And you point to the record, but I don't see that. Can you just point me to where the record support is that there was some joint agreement that you would retire early?
I certainly can clarify that, Your Honor, Justice. That, in fact, it did not happen. I tried to elicit that testimony, and it certainly does come in on the in the transcripts where Attorney Russell was able to object, and his objection was sustained when I was trying to get that information in. But the wife did testify, and it was not objected to, that she, because of health reasons, she decided to retire early because of her health reasons.
Where is that in the record on appeal?
I can just have a moment, please.
At the transcript at page 157, the question, and it was sustained, did they consider you to be retiring early? Objection sustained. So I don't see where that came in. But there is a further question on 158, did you retire early from the high school? And the answer was no.
I apologize, Your Honor. What page are you on?
158. You ask your client, did you retire early from Wachusett Regional High School? She answers no. There's then an attempt to get in a disqualified conversation between the husband and the wife that the judge excludes. So the only evidence we have is your client's statement that she did not retire early. So I'm just a little confused. And I realize that you're almost out of time. So let me see if the panel has additional questions.
I don't have any additional questions. In looking at the site for your argument that they both agreed, which is page 84 of the transcript, I don't see where they both agreed, but it doesn't appear that she says she chose to retire at 58 because she had health concerns.
Correct.
Not sure that carries the day.
All right, Mr. Russell.
Thank you. Francis Russell representing Franz Steiner. First, Justices, I'd like to point out that the point you just raised about a statement of something that actually did not make it to the record, having been cited by my sister in her brief. As I pointed out in my motion to strike the brief, not only did it contain statements that the judge had excluded in evidence as those that were purported to be in the record, when the record was submitted, it was first submitted at the time of the filing of the brief to the court without my having had the opportunity to address the improperness of the record in the lower court. Included in the record for Your Honor's perusal is a transcript of a deposition taken of the plaintiff in this case prior to the trial. That deposition transcript, nor its contents, was presented to the trial judge for consideration in making her findings, yet the brief submitted is replete with that type of information, as well as what I would submit are references to a record that don't match the statement for which they're purported to mention. So I would rely on the Avery versus Steele case when I ask Your Honors to consider those factors. In that case, it says that statements referencing information outside the record infects the integrity of the appeal to such an extent that it would be rendered frivolous.
Attorney Russell, the two transcripts in your sister's appendix, one for August 7th and one for March 11th, are those, you say those are deposition transcripts?
Yeah, she makes reference even in her table of contents, Justice Blake, that those were excerpts from the husband, in this case, Franz Steiner's deposition.
But when I'm looking at, for example, record 23, this is a transcript that says trial before the Honorable Jennifer Amelia. So I'm confused, I think, as to what you're saying was a deposition transcript.
If you look in her record appendix that she submitted with the pleadings to this court, you'll see her table of contents.
Yes.
And if you look to the table of contents, pages are referencing, let me find it, Your Honor. Yes, I'm sorry. It's on her record appendix, page 2. The transcript dated, she references transcript dated March 11th, 2019 on page 100. If you go to page 100, Your Honor, and that goes from
so that's the deposition, but the earlier transcript is in fact a partial trial transcript.
Right, she's taken excerpts from that trial and also has included 40 pages of the plaintiff's deposition. But let me go back to the other questions about the alimony issue. It's certainly our position that the judge did take into consideration all of those factors in Mass General Laws 208-53. You'll see from the judge's findings what she determined to be the party's income. What you see in the transcript, which if you look at the supplemental appendix that was filed by me with the court's approval, where it has the entire transcript, the evidence that was before Judge Melia at the time, there were a couple of issues. One, with respect to this whole concept of bartering, the testimony, which she believed, indicated that my client, Your Honor, moved into a combination workshop and place where he was going to make his home. The place had not been built out to be in a habitable condition. The landlord did not have the funds to pay for the repairs. My client actually borrowed money, that's in the testimony, to pay for those repairs. And what he was crediting against the agreed upon rent was the amount he had expended in large part to pay other contractors to do the work. It wasn't simply, I'll paint your house and you let me live there. It was out-of-pocket funds that were there that Judge Melia took into consideration. She also had before her that the parties, up until the time the family home had been foreclosed upon, was a 4 to 5 bedroom home that was one that they had invested a fair amount into, and that was the lifestyle they lived during the marriage.
The problem, though, with all of that, Attorney Russell, is this is a very thin set of findings and rationale. Right?
Well, part of it is not so thin, Your Honor. The part that shows that credibly the information regarding Mrs. Steiner's income was $2,637 per week, and Mr. Steiner's was $588 per week. That's not very thin in most.
She never really discusses ability to pay and need, and now I know we don't have the financial statements from the time of trial, which might have given us some background for that. So why wouldn't it be appropriate to remand this case for additional findings?
Well, I would suggest again, Your Honor, in addition to those matters I meant that are part of the record that shouldn't be there, I don't believe that this court would reward the appellant who doesn't submit parts of the record that bolster her argument. Because that's not before the court, you don't have the benefit of that. Getting a redo is benefiting or rewarding an improper record presented by the appellant, which I think is the case not just with that issue, but with those other issues referred to in my, not only in my brief, but in my.
But if we have no financial statements to consider and we have only what the judge described under the needs and the alimony section of her findings and rationale, help me understand where I see or where I can infer an ability to pay and a need.
Well, I think in the disparities of the party's income, Your Honor, and I think if the evidence is not presented through either the record of the trial or in the record appendix submitted by the appellant, I think that the trial judge should be certainly to make a finding that that judge was grossly negligent in making those findings is punishing the trial judge for the fact that the information that the appellant is relying upon, saying that that factor or that need wasn't shown, is because she hasn't submitted the document. That's not fair to the trial court. I think we afford the trier of fact the deference of having made those decisions.
But she has to say something, right? We have 2834, we have mandatory factors. And even if we had the financial statements in abundance, she doesn't really go through the Section 34 factors or the alimony factors.
I would suggest that she has, and that the appellant has not produced any evidence to show that her findings or her judgment with respect to having met those factors is plainly wrong or excessive.
You filed a supplemental appendix for what purpose?
I did that, Your Honor, because there were, in addition to including in the record appendix that the court received that included matters outside of the record, I felt that there were a number of instances in the appellant's brief that was filed with the court that misstated the facts of the record, particularly the one that you brought up just a bit earlier about the joint decision to retire. I thought that unless the court saw the entire record, that wouldn't come through. Also, with regard to my sister's talk about bartering income not being considered, the evidence or the facts that the trial judge heard had to deal with this loan taken out by my client to pay the electrician, to pay the plumber, to get the property into a habitable condition, and then to credit the landlord the amount of the rent he would have received by what my client had paid to outside vendors who the landlord could not afford to pay. Without the court seeing that, I felt too much reliance might be placed upon what my sister had in her brief regarding this quote unquote bartering issue.
What did you ask for alimony?
Probably more, Your Honor, but it was probably a higher percentage, but I was not challenging the income of the spouse. I looked at a 36-year marriage with the spouse making $2,637 per week and the other spouse, my client, making $580 per week. The evidence showed the parties lived in a comfortable 4 to 5 bedroom home throughout a good part of their marriage where they raised their children. My client became disabled in 2014, and it was shortly after that that the home was foreclosed upon. And that's all part of the record, the supplemental record that I presented, Your Honors. So that's what I was looking at in determining that to live not to live in the unfinished, the testimony was he had to use a bathroom of a friend because there wasn't one in the place he was living. But the lifestyle they lived during the course of the marriage wanted an alimony order based on the disparity of the parties' income and based upon the ability, based upon Mrs. Steiner's income, to pay that alimony. And I think the judge agreed with that based upon the evidence that she heard. Whether she did 20 pages of findings to support that, I can't control that. But I also don't believe that the appellant should be rewarded for not having presented to the justices a record that would raise questions about what the judge's decision-making basis was. To leave out that financial statement but say the judge didn't consider the proper factors about need and ability to pay is giving more deference to the appellant than it is to the trier of fact whose facts are final. And unless she's proven to be clearly erroneous or excessive, should be upheld. And I also think that based upon the Avery versus Steele case, when the court takes a look at this record appendix that was submitted by the appellant, the court should find that that appeal is deemed frivolous because of the infected record with outside information and improper citing of facts not in evidence.
You filed an affidavit of fees, but in your brief, you don't request fees. So how are fees before us?
Your Honor, and that I would suggest that I did bring a motion to strike the brief and requested for fees there. And I also recognize that Appellate Court Rule 25 would allow me, if the court found that that brief was frivolous, to then seek fees after that. I filed that affidavit as a supplement to the brief to the affidavit I had filed with my motion, where I did seek fees and costs at the time of the filing of what I considered to be an incorrect and totally outside the rules of appellate procedure brief, which violated Rule 8 right from the get-go, where it included in the record matters that were not part of the court record in any fashion.
You would agree that the judge in her findings and rationale never mentions the Alimony Reform Act by name or by statute, right?
I think she names it by inference. I would agree that it's not named by name or by statute, but when she looked at the factors that there was now a difference between the act, which has the statutory amount in its guideline of 30 to 35%, and reduce that to 25% based upon the fact that this alimony payment by Ms. Steiner would not be considered tax deductible. I think she made that reference by inference, at least in my opinion. And I would again, Your Honor, it wasn't discussed with the appellant, but certainly I believe Judge Melia went through the 208-34 factors in determining how to divide the other asset of this marriage, which was the state retirement pension that Ms. Steiner had testified that she took because she reached the 80% amount. And that was reached about 4 months before the filing of the divorce. The argument in the brief for appellant about that not factoring in other things that the judge should have considered, like Social Security. As the court's aware, the cases hold that Social Security is not a divisible asset, but the court can consider it. I would suggest that Judge Melia's findings, where she divided the pension but assigned to my client the total cost of the election of a joint and survivor annuity, was tantamount to an unequal division. My client is getting a percentage, a good percentage less than Ms. Steiner will receive. She'll receive the same benefit she would have gotten under option A, which would be the highest payment to her. And all of the cost of electing a joint annuity would be borne by my client. So she did an unequal division of that asset, recognizing, I would say, other factors that she had been entitled to. So I don't feel that there's any mistake or excessive or plainly wrong issue with respect to the division of assets.
Let me just see if the panel has any other additional questions. It doesn't look like it.